From the 47th District, Representative Dubitsky.
Thank you, Mr. Speaker. Mr. Speaker, I have no questions for the proponent, so he can certainly sit down. As the Chamber knows, I usually, when I speak, I often speak for or against the bill that is up on the board. Today, I'm not going to do that, what I'd like to do is take my time and explain a consideration that I have in deciding whether or not I'm going to vote for this bill. And I hope that my colleagues take this into consideration as well. And I'm going to focus my remarks on the elimination for a number of crimes of the Statute of Limitations. In this bill, this bill would eliminate completely any statute of limitations for a number of crimes. Now, I am typically a pretty strong law and order guy. I consider myself a strong victims advocate. I support long sentences for people who've done horrible things to other people. Little background about me: when I was in law school, I worked with one of my law professors. His name was Paul Cassell. He took a case to the U.S. Supreme Court arguing that Miranda versus Arizona was wrongly decided. You may have heard of that case. That's where we get our Miranda warnings, where you hear you have a right to remain silent, anything you say can and will be used against you, etc. He believed that that case was incorrectly decided, and that police do not, in fact, under our Constitution, need to read this document to them as they're arrested. And I supported that. The case called Dickerson versus United States, that argument lost. So now it is absolutely, conclusively, that police do need to read that. But that just, I think it just shows a little bit about my background, that I'm a pretty strong law and order kind of guy. I have absolutely no sympathy for rapists and people who engage in sexual assault. At the same time, I'm also a strong constitutionalist. I take the Constitution very, very seriously. And in the Constitution is the Sixth Amendment. The Sixth Amendment guarantees the right to a fair and speedy trial, and guarantees a defendant compulsory process for obtaining witnesses in the defendant's favor. And what I have to do, and what all lawmakers do, is we have to balance the law and order side and the constitutional protection side. On my right side, I have a voice that's screaming, "Fry the bastards." My left ear, I've got a voice that says, "Protect the accused." I've got the victim's rights voice, and I've got the civil rights voice. And it's my job to figure out which one to listen to in any given situation. And one of the things as a constitutionalist I cannot do is let my personal inclinations to string up rapists override the constitutional mandate to protect fundamental civil rights. Everyone, no matter what the allegation against them, has a right to a fair trial. Now, I don't know if I'm going to vote for or against this bill. I'm hoping for some debate to help me decide. My decision, when I do decide, is going to be based on whether or not it allows for a fair trial of a person charged with some of the worst crimes that one person can commit against the other. Now, what's the purpose of the statute of limitations that we would be eliminating in this bill? There are several. One is an interest in having claims dealt with in a timely manner, that if a person has a claim against another person, they should bring that claim with reasonable diligence. Now, in the case of sexual assault or rape, we've heard testimony that that may not necessarily apply. There are people who have to heal over the years before they can get up the will to make a report. So I don't necessarily think that that factor applies in this instance. There's the interest in preventing people from filing stale claims merely for harassment purposes. Now, again, except in very unique and limited circumstances, I'm not sure that one applies. But the one I think does apply is the statute of limitations prevents facts and evidence from becoming stale, unclear, and undiscernible. Over the years, memories fade. Memories become inaccurate. Evidence is lost or becomes unrecognizable. Witnesses die or move away. It can become nearly impossible to find evidence for a defendant to use to show that he didn't do it. When we're talking about 30, 40, 50 years after the allegation, after the alleged incident. Now, it's certainly true that evidence of a crime can be preserved for decades, even centuries. But evidence that might help show that somebody didn't do it is often lost fairly quickly. So I'm going to recite a quick scenario, and I'd like specifically those people over 50 years old to pay particular attention. So you're sitting there in your backyard with your new grandchild on your lap, and you may be retired after a long career. You haven't seen anybody from high school or college in 30 or 40 years. Somebody comes to your door and says, "We're investigating an allegation that 40 or 50 years ago you were involved in a given situation in high school." Who do you call? Where do you go to find evidence that you didn't do it? If you have absolutely no idea what this person is talking about, how would you go about trying to prove that? You may not know anybody that was there during that period of time. Many of those people may be dead. They may have moved away. The place where it happened may have been bulldozed decades ago, and now it's a shopping center. You may not have any records, any documents from that period of time. You certainly don't have any clothes how do you go about showing that it wasn't you? Now, after 10 years, okay, 10 years, most people have a pretty decent memory. You can track somebody down after 10 years. You may have some documents. You may even have computer files. But after 50 years, 60 years, how do you come up with evidence to defend yourself? Now, there's some discussion in this bill about DNA evidence. And DNA evidence, based on what we see on TV, is always, it either is or it isn't. It's like a light switch. It's on or off. But anybody who's worked in the legal field understands that that's not necessarily the case, especially after many, many decades. DNA evidence degrades, especially if it isn't handled properly, if it isn't stored properly, if it isn't collected properly. DNA evidence is I've heard it called something like the negative of a photograph on a piece of acetate with an image on it. You sit it down on a piece of paper and you can tell what it is. It's very unique. Over time, it starts to fade. Maybe it starts to fade a little unevenly, but you can still see it. You can still tell what it is. It's still unique. But very often, DNA samples are mixed samples with a number of different people's DNA all mixed together in the same sample. And that sample degrades unevenly. So just consider multiple negatives laid down on a piece of paper on top of each other, stacked up. You've got a whole bunch of different images that you're looking at that are degrading, that are fading at different rates in different parts of the images. It becomes much more difficult to determine which layer any given image is on. And the longer it goes, the harder it is to figure it out, and it becomes a matter of interpretation. It's not a light switch on and off. It takes experts to try to figure out, is this particular piece connected to this person, or is this person's image even in that picture? The longer it goes, the harder it is. After 50 or 60 years, depending on how well that sample's been preserved, it can be impossible. Now, it's true that the prosecutor still has a burden of proof. The prosecutor still needs to be able to present sufficient evidence to convince the jury that you were the guy. But the jury listens to both sides. The jury listens to evidence presented by the prosecutor and by the defense. And if the defendant can't find any evidence, that no evidence is left after 40 or 50 years, makes the prosecutor's job a heck of a lot easier, even if the defendant didn't do it. So, after 40, 50, 60 years, how do you defend yourself against an allegation? How do you get a fair trial? The civil rights voice in my head is skeptical that it can happen. And the victim's rights voice is hoping that during this discussion, somebody can convince me that the civil rights voice is wrong. Thank you, Mr. Speaker.